Hi everybody, good afternoon, and thanks ever so much for dialing in today. And we have got quite a few people registered for this webinar, so we're just going to give it a moment or two just to allow everybody to join and get comfortable, and then we'll begin. That's great. We've got quite a few people joining already now. So yes, good afternoon, everybody. My name is Faye Stinning and I'm a marketing manager here at InfoTrack. I'd like to welcome you to today's webinar, where we're going to recap on the recent changes to the conveyancing quality scheme, what's likely to come next, and also how to ensure CQS compliance and the technology available to support that journey through integration with Advanced P4W or Advanced ALB and InfoTrack. So taking you through today's webinar, I'm delighted to be joined by Tracy Thompson, who's a lead assessor for CQS, and Tracy will then be joined by InfoTrack's Northern Sales Manager, Lisa Edwards. So before we begin the webinar, I'd like to draw your attention, please, to the Q&A tab, which is located at the bottom of your screen. We will run a Q&A session at the end of this webinar, so please do type any questions that you might have, either for Tracy or for Lisa, along with your name into the Q&A box. And that way, if we run out of time or if your question requires further clarification, we can extract your details and your information and follow up with you directly after the webinar. So without further ado, I will hand you over to Tracy, and she will take you on the CQS webinar journey. Thanks, Tracy.
Fabulous. Thanks very much, Faye. Good afternoon, everybody. For those of you who haven't come across me before, my name is Tracy Thompson. I am a lawyer and was appointed as lead assessor for CQS back in 2019. Which seems an awful long time ago now. What I'm going to talk to you about today is just to give you a bit of a recap in relation to the changes which occurred last year. I'll take you through those changes so that it gives you the opportunity to make sure that in your own practice you can go back and cross-reference and check that you have made the updates that you need to make. And then I will give you a little bit of an insight into the current patterns and trends which we're finding with CQS practices. And then to finish, just to give you a bit of an update as to any changes that you might see with CQS in the coming months. So without further ado, I shall make a start. Okay, so hopefully you are all aware as CQS accredited practices that we had some changes that were made in 2022. So probably about this time last year, the Law Society made the announcement that there would be a new core practice management standard, which became compulsory for practices to follow in their own firm from the 1st of May. And we also had the announcement that there would be the formal launch of the on-site assessments, which would also take place from the 1st of May. And the Law Society at that point said that practices needed to make sure that they were assessment ready from that date. So what I'm going to do is take you through what those changes were on the 1st of May 2022. So as I say, you can go back and cross-reference and make sure that you are reviewing your CQS policies and procedures, make sure that you're compliant in practice, and I will lead you through those now. So the changes that we saw in 2022, we saw an increase overall in the core practice management standard. We saw a reformatting of the CPMS. So it aligns a lot more with Lexel. So we originally had 6 chapters in the 2019 version of the core practice management standard. The current version was increased to 7 chapters, and that mirrors Lexel. And within that reformatting as well, the numbering kind of aligns with Lexel. So for Lexel accredited practices, it is easier for you to be able to identify kind of the identical nature of the 2 standards. So obviously it's easier for you to manage that process in your practice. We also saw an increase from 34 individual requirements of the 2019 core practice management standard through to 40. That doesn't necessarily mean that there were an additional 6. Some of the requirements were just split out. So we have 40 specific requirements, some of which are complex and some of which are, are pretty straightforward. So they all vary in differing degrees as to how much work needs to be put in relation to your documented policies or procedures, or what you do in practice, and obviously how you evidence that. So we saw updates, or more significant updates to all of the sections apart from structure and strategy and financial management. So there weren't any significant changes which took place in those sections. But what I will do now is just run you through the other sections where there were some changes, so that you know what to look for if you haven't looked at the standard since that update. So information management and security, which is chapter 3. We saw some changes here. Now, what I will point out to you is if you are familiar with the 2019 version of the Core Practice Management Standard, and now you look at the 22 version of the standard, you will see that there have been some information has been stripped out. So take these two particular requirements. So data protection and information management and security. We found in the 2019 version at 6.1 and 6.2, and they were pretty chunky requirements. So there was a lot of subsections. So we had 6.1 A through to, I think, J, and 6.2 had a similar amount of subsections. So there was quite a lot of detailed information there that clearly set out that to meet the requirements of CQS, your data protection policy needed to include A, B, and C, and your information management security policy needed to include A, B, and C. What you'll see now in various parts of the revision is that information has been stripped out. However, what I would say is when you are reviewing your policies and procedures, or whether you're at the beginning of your journey and you're only just starting to deal with your documented policies and procedures and what should be in those policies and procedures, always look in the guidance. So when you access the Core Practice Management Standard, the document itself does have guidance notes contained within that same document. If you look at the guidance notes, you will see that those are the minimum expectations that the Law Society expects to see in place. So for 3.1, for example, data protection, everything that's been stripped out of the previous version, you will see in the guidance notes. And similarly with 3.2 with the information management and security. So everything that was kind of detailed in 6.2 previously, like dealing with firewalls and updates to your software and managing user accounts and these kind of things that we saw in information management and security do actually appear in the guidance notes. So they are still expected to be there. They are still expected to be contained within your documented policies. So just a little tip from me there. If you think, say for example, with 6.2, which is client care requirements, oh, we don't need to tell the clients anymore everything that was listed in the 2019 version of the Core Practice Management Standard. You do, it's just it's been moved to a different part of the standard. So just be aware of that. So the guidance notes form part of the minimum expectations that the Law Society expect you to have in practice. So we still have the requirement to have a data protection policy. We do have a new requirement here, which is ensuring that all personnel are kept aware of developments in cybercrime and how they may affect the practice. So that's something that you need to give consideration to. Obviously, cyber is a huge risk in all legal practices. Information management security is a must and should be accredited against Cyber Essentials. That hasn't changed, other than the detail has been stripped out and put into the guidance notes. At 3.3, which is a new requirement, so this is where practices now need to have a complete register of all of the plans, policies and procedures that are contained within the Core Practice Management Standard. So that is everything that we see in the whole of the standard. We need to have a named person that will be responsible for each of those particular requirements. And then we need to have a procedure So do bear in mind that if the content of the core practice management standard states that it is a procedure that's needed, then that needs to be documented. So it's not good enough to say, well, I do that, or I would have done that. You need to make sure that you document it. So a procedure is a written set of steps that you will take to achieve an outcome. So for example, here, a procedure would be, on an annual basis, we will review each policy, plan and procedure contained within the core practice management standard. The people involved in that review will be, A, B and C. The review will take place, at this time of the year, and considerations for that review will be internal patterns and trends, any guidance from any third parties, updates to legislation, updates to regulation, updates to core practice management standard, or any guidance, for example, LSAG or quality standards generally. So those are the kind of things. That's the kind of thing that you would put in that procedure, but you do need to have that documented so that we can see what is it you intend to do, and how often, and who's involved, and what will that take into account. So that's a new requirement in this version of the core practice management standard. Then we'll move on to people management. So this is a completely new chapter. So this was the additional chapter that didn't appear in the old core practice management standard. So it now aligns with Lexel. We have slight variance in the learning and development policy, which appeared somewhere in the old standard. We now have the requirement to include ensuring that we give consideration to appropriate training being provided to personnel. So think about who needs training, what training is appropriate to their roles. We need to make sure that supervisors and managers receive appropriate training to be able to carry out their roles effectively. And we also need a procedure to evaluate training. So again, what does that look like? The spirit of evaluation is, not just the quality of the speaker and the notes, and whether the venue was warm, etc. The spirit of evaluating training is, what have I learned? What am I going to put into practice? What am I going to change going forward? So do be mindful of that. We also have a new requirement as well, which is having to undertake a documented induction for personnel. So this induction, I'm sure when somebody starts in the practice, you have some kind of process that you go through, but you need to make sure that the induction itself covers identifying immediate training requirements. So how do you do that? What does that look like? And making sure that that induction covers key policies as well. Also, ensure that the induction covers people transferring roles within the practice. So it's not just about new starters, it's about people that are moving around within the business. If you've got a trainee, for example, and that trainee has done a seat in crime and then family, and then they're coming to residential conveyancing as the third seat, then it's important that you carry out an induction for them, because their training requirements and the key policies for this particular department are going to be different to what they would have potentially needed for the family and criminal departments, for example. So that's new in the 2022 version. Moving on to the chunkiest section of the standard, which is risk management. We have some amendments here. So we have a new requirement, which is ensuring that personnel adhere to the Law Society Conveyancing Protocol. So if you kind of picked up on the last slide, or know the standard as well as I do, you will know that 4.1, there is the requirements to ensure that all personnel are aware of the core practice management standard and how the practice complies in practice, and also that they're aware of the conveyancing protocols. So that's the same. However, what we do have is this new requirement whereby you need to make sure that you have procedures to ensure that personnel are actually following the protocols where they can. So again, none of this is prescriptive. You need to figure out how that works for you in practice. I always think that file reviews are a really good opportunity to be able to extract the data and actually identify if the protocols are being followed in practice as part of your independent file review procedure. So that's the amendments for section 5. Obviously, we have 5.8. We have an error in the core practice management standard as it stands at the moment. We have two 5.8s, but obviously I imagine that when the next wave of updates comes along in relation to that, it will be updated accordingly. So moving on to 5.9, 5.12, I think I've lost a slide there. Oh, I have actually lost a slide. Okay, so I don't quite know how I've done that, but I will look into it. What we have here is the end of slide which relates to 5.12, which is anti-money laundering. So we have quite a chunky section on anti-money laundering, and there are some slight amendments. So we have an amendment whereby we need to have a procedure in place for dealing with source of funds and source of wealth. The update is that we need to make sure that we keep on file both the evidence obtained and the documented analysis. So obviously, when we're looking at anti-money laundering, we have a requirement for making sure that we're complying with legislation, regulatory obligations in relation to anti-money laundering. So, it's a pretty complex area to be following in practice anyway. When we're looking at anti-money laundering, source of funds, source of wealth, then that is an area that practices should really be looking at deeply to make sure that that fee earners in particular are going to the right lengths and ensuring that they are able to join the dots and they are looking at the difference between source of funds and source of wealth. And, there is a difference. Evidence of source of funds is obtaining evidence that the money is in existence and, this is where it is. So it's £80,000 in HSBC account because you've got a bank statement demonstrating that. And source of wealth is establishing with the client as to how that wealth is accumulated and making inquiries and investigations to ensure that, that there is no suspicion or knowledge of money laundering or being a proceed of crime. So there is this requirement to have a documented analysis. A documented analysis, always look at the wording of the standard. A documented analysis is not a tick in a box. It's not, an initial on a checklist. It is an analysis. So, if you think about the SRA or the NCA coming along on a Saturday afternoon and they're looking at your residential conveyancing file and they want that file to tell a story without anybody over their shoulder identifying this is what we've done and why we've done it, then, think about the evidence that they need to see. And that is, we have all these bank statements, but actually what is the analysis? The analysis is this is where the money is. We can see this money's coming from here. This is how it's been accumulated. I have no concerns or I have no suspicion. So something that the fee earner has actually set out that this is what their thought process is. We also have the requirement to make sure that we have an individual matter-based risk assessment. So this is new to CQS, but it's not new to the regulations. So we've got Regulation 18, which is your practice-wide risk assessment, which has appeared in Lexel since version 1. A few years ago, but we now with CQS and Lexel have this requirement for ensuring that we have a documented risk assessment on every matter, and this is specifically in relation to anti-money laundering. So you have your operational risk, you have your anti-money laundering risk assessment, and this is Regulation 28. So like I say, it is a regulatory and legislative requirement. So you do need to make sure that you have that risk assessment. And again, there needs to be engagement with the process, not just a tick in a box, not just a signature. There needs to be some demonstration to be able to comply with the SRA's requirements that the fee earner is engaging with the process and continuing to review that assessment throughout the course of the matter. Obviously, that document can be tied in with the procedure for checking source of funds and source of wealth. We also have in section 513, which is property and mortgage fraud, a requirement for having a practice-wide risk assessment for identifying fraud. So this is, think dream bar, think, the high value, unencumbered property where the seller lives abroad and it's empty, you know, and there are warning signs there. So that would be, you know, typically your starting point at putting together your kind of practice-wide risk assessment of, you know, what you might be exposed to in relation to fraud, property and mortgage fraud. So that's new, but we also have the requirements as well, which I'm just going to kind of point out to you, to have a matter level documented fraud risk assessment. So again, this is your third risk assessment on your residential conveyancing matter. Although it's not new, it is something that that I see is missing in a lot of practices that that actually I deal with. Moving on to 5.15, we have an amendment to SDLT policy, and that's only a slight amendment from the previous version. So we now need to make sure that when we're giving advice to the client at the outset, that we need to give them a full definition of what first-time buyer and major interest in a dwelling is, so that they can make an informed decision. You know, if you're asking them to declare if they're a first-time buyer, but you're not actually explaining to them what that definition is, then they're not making an informed decision, and then, you know, that exposes you to potential risk. So so that's something that's new, and you need to make sure that the clients are being provided with a clear written SDLT calculation to the client at the outset. So that's a slight amendment on the previous version, but other than that, the SDLT provisions remain very similar to how they were before. In relation to leasehold property, so this obviously is an area that has caused some difficulty for practices in recent years. Slight amendment here to the, you know, the definition of what needs to be included. So we need to have procedures for ensuring that full, clear and accessible written advice is given to the client on the lease and supporting documents. So the spirit of that intention is that you're not providing a copy of a lease to a client to say, you know, here's your 47-page lease, please ensure that you read it thoroughly and ensure that you comply with the tenant's covenants detailed in Schedule 4 on page 12. You know, that is not full, clear and accessible written advice. So you do need to make sure that, you know, that everybody is aware that your advice needs to be in writing, and you do need to set out clearly what those covenants would be, for example, and how they affect the client. You also need to explain the difference between freehold and leasehold property to the client. Don't assume that they know. So that's something that has been incorporated into this particular requirement. And key information that might be appropriate to that particular lease, again, need to give clear, written, accessible advice to the clients, and give consideration to the lender's requirements regarding that particular lease and leasehold transactions generally, and make sure that you are advising the client specifically in relation to those. Client care, so this is section 6 of the standard. We have slight update, as I mentioned earlier, in relation to 6.2. So this is previously in the 2019 standard. There was a lot more information in here about providing, you know, the client with information as to, you know, who the fee earner is and what their status is, who the supervisor is, what their status is, etc., etc. Again, that might have been, it's been moved into the guidance, but hasn't actually been moved out of the standard at all. So it's just a minimum expectation, but it's just been stripped out of the particular wording here. So, so we need to make sure that we communicate to the clients in writing, you know, all of the information that we need to, you know, with our terms of business, with our client care letter, making sure that we comply with regulation, making sure that we comply with CQS and those minimum expectations, but specifically explain the likely timescales of the transaction and anything that might affect those timescales, but also make sure that we set out some levels of service as well, which I know not everybody likes to publish and tell clients, but you do need to set out some service standards to the client there under these requirements. 6.4, lenders, dealing with lenders, we have slight amendments here. So we need to make sure that we set out to the client that the lender is also a client, where you're acting for both of them. A lot of practices, I see that kind of buried in their terms of business. As long as you're telling them somewhere, that's absolutely fine. But then we have this new requirement, which again, I'm not seeing a lot of in practice at the moment, and that is that we need to have a procedure in place to ensure that our fee earners are checking Part 2 of the UK Finance Handbook, and that they are verifying that those requirements have been satisfied and recording it on the file. So this is something you need to give some consideration to, you know, about how is that going to happen in your practice. You'll all have different ways of working, you know, to have a think about, you know, what is best for you and how that can work, and also have a think about when the checks can be made as well, because obviously these things are updated on a very regular basis. So, you know, with all of these things, you know, there is software available, and tech is a great way of being able to be able to meet these requirements, but also to be able to demonstrate them to the lender if requested, or if you know, when you're selected for assessment, the CQS assessor. In relation to complaints handling, some slight amendments here. You need to make sure that that the complaints procedure is available for the client, and it is published on the practice's website, which obviously will accord with the SRA transparency rules. We also need to make sure that the complaint is dealt with promptly, fairly and free of charge. So you need to set that out to the client in your complaints procedure. And you also need to make sure that you deal with the regulatory obligations, which is telling the client, there's an overlap here, telling the client that you deal with the complaint free of charge, identifying to them that they have the right to refer to legal ombudsman, identifying your position in relation to mediation, so whether you subscribe to alternative dispute resolution, and also informing the client that they have the right in certain circumstances to refer to the SRA if, say, for example, you know, there's a suspicion of breach of code of conduct or discrimination, for example. You also need to make sure that not only are you recording your complaints centrally, that you're doing root cause analysis and you're keeping detailed records in relation to those complaints and why they happened, and obviously what remedial action has been taken to prevent any reoccurrence. File and case management, section 7. Amendments here, we have a new requirement at 7.4, which is to have a procedure in place that will reduce avoidable requisitions from HMLR. Obviously, we all know the issues that HMLR are currently having. So what they're talking about here is, you know, the silly requisitions, the two documents, you know, Tracy's got an E in one document and no E in another. And obviously I use that as a real example because everybody puts an E in my name. You need to think about kind of how you can manage that process in terms of your preparation for your AP1. And again, you know, tech support is really helpful in these regards. You also need to make sure that you're advising clients that they're able to register up to 3 service addresses, including an email address. Again, you know, how you do that is up to you. It may be that your questionnaire, which you send to the client at the outset, that you get that information from them, so you can then feed it into the transfer further down the line, or indeed it may be that once you've had your title information document back, that you give them that information either at that point or again. And then finally, moving on to 7.5, which is closing procedures. We need to make sure that we have documented procedures for archiving and destroying files, and then obviously make sure that when we get to that point that we are actually archiving promptly in accordance with our procedures, and we are destroying files in accordance with data protection principles. So those are the updates to the core practice management standard. In relation to the on-site assessments, which was obviously you know, something that was new in May 22, the on-site assessments did commence. They've been carried out since May. They are currently being carried out, although albeit in small numbers at the moment, but that will the numbers will increase as we, as the processes become more refined. In terms of the practices that are being selected for assessment, it's the Law Society that make that decision as to who is assessed and when they are assessed. And what is clear is that there is, quite an early emergence of core patterns and trends, which, to be fair, when the Law Society carried out their on-site pilot, which was from November 2019 through to February 2020, and we went out and we carried out the pilot, we saw the same patterns and trends. I do a lot of work with practices, helping them kind of get ready for CQS inspection, making sure that they are compliant and and helping them improve. I'm carrying out kind of CQS review, for example, and I see the same core patterns and trends throughout the profession. So I will identify those for you. But just before I do, if you've not come across me before, then you won't have heard this before. But what I talk about a lot is the three-tier process. And if you take nothing away from today, this is what I want you to take away. So to be able to demonstrate compliance with CQS or Excel or any other practice management standard or any other quality standard, or, indeed for, when we're looking at kind of regulators or, any external authorities, what we need is this three-tier process in place. And I always describe it as say as you do as you say, and provide the evidence. And quite simply, as an auditor, this is what we expect to see in practice. So you say as you do is all your documented policies and procedures. You do as you say is making sure that you follow them, and providing the evidence obviously speaks for itself. So there is this kind of misconception that, if I'm doing something, then that's good enough. So firstly, it's not. You do need to have a documented policy or procedure, depending on the wording of the standard, that actually sets out what it is that you're going to be doing. So always look at your core practice management standard, look carefully at the wording, and identify that this is what I need to be ensuring is in my policy or procedure. You sit down, you have a conversation with people, you consultate, and you identify, okay, this is what we're going to do. So you document it. So that is your documented procedure that says you will do A, B, and C. Then you make sure that in practice, everybody is actually following A, B, and C. If when we come out and do an audit, the actual reality is that fee earners are doing D, E, and F, then what you'll find is that you're in breach of your own policy. So you do need to have an alignment between say as you do and do as you say. So always make sure that you do consult with fee earners, consult with departments, with the support staff, and actually identify that this is what our policy says. Is this actually what happens in practice? And give people the opportunity to actually put their hands up and say, well, actually, no, I don't. I do it this way. Or I do on 95% of occasions, but actually on 5% of occasions, I need to depart for this reason. And then it's up to you as a practice, for your decision makers, to make an informed decision as to whether the policy needs to be updated so that that departure can take place, subject to whatever authorizations, or whether it's a case of actually, no, we've identified the risks. These are our controls and measures. You follow A, B, and C. You don't depart from that. So that one's really important. But then the third measure of that is providing evidence as well, and making sure that that people understand that there is a reason for that tick in the box. There is a reason for completing that form. That might just be the evidence that is needed to be a proactive action to demonstrate that somebody has carried out what it is that they need to carry out, and because that's what you say you do, but also that somebody is being accountable for having carried out that action as well. So that's the most important thing I want you to take away from today. Three-tier process: say as you do as you say, and provide the evidence. That's what you need to look at for the whole of the core practice management standard. Just some of the common areas of non-compliance, as I say, patterns and trends which are coming through on probably 2 or 3 occasions a week where I'm working with practices in relation to CQS, wearing my CQS consultant hat rather than CQS assessor, obviously not the same firms. Business continuity plan testing, make sure that you have a documented approach. It is a requirement, and make sure you do have evidence of that testing having taken place as well. In relation to financial verification, so checking bank details before you send monies out, whether it's to a client, whether it's to a third party, ensure that that stance is documented and obviously followed in practice. And also consideration of high-risk third countries as well. Tend to see a lot of documentation is missing the consideration that when we're making international payments, or whether when we're receiving monies in from international clients, or from international accounts, lack of consideration of high-risk third countries and sanctions, and how we're going to deal with this. Anti-money laundering, key areas of non-compliance, which I see in probably 95% of practices, and that is the AML matter risk assessments, either no engagement with the process, so a tick in a box, and the SRA don't like that. It doesn't demonstrate any engagement with the process at all. Matter risk assessments that are inadequate, matter risk assessments that are just not completed, or not completed properly, or, as I've seen a couple of times in the last week or so, risk assessments that are actually completed too early. So they're actually completed as part of the onboarding process, and then that's it. You need to be able to demonstrate that this is an ongoing consideration of all things AML, including source of funds and source of wealth, and knowing your clients and PEP status, and everything that you think about right the way through the transaction. So onboarding and then sending that form off somewhere is not going to satisfy that requirement. Source of funds, source of wealth evidence, again, ensuring that everybody is aware that there's a difference between source of funds and source of wealth, making sure there is evidence on the file, and making sure that there is that documented analysis, which I see missing in probably certainly 95% of practices that I deal with. And then we see a lot of practices where they are silent on the point of having an independent AML audit function carried out, and the appointment of an MLCO, so the Money Laundering Compliance Officer. If you have a look at the AML thematic review report that was published, I think, in October 2022, that gives a good indication of what the SRA have seen as part of their AML thematic review. And these are areas where they have specifically raised points. In relation to the AML audit, I think of the practices that they visited in the last 12 months, 50% of those practices said, we are not of size and nature where we consider we need an AML audit. And in 50% of those cases, the SRA said, actually, yes, you are, because of the type of work you're doing, the profile of the practice, you've got multiple fee earners, you've got, you might have multiple offices, you might be dealing with high net worth clients. So it's about your individual profile. And what the SRA did actually state back in 2020 was that unless you're a sole practitioner, with very little support around you, and you're the only fee earner, then they would expect that your practice is likely to need that independent AML audit function carrying out. So do look at that. Property and mortgage fraud, matter risk assessments. Not very often do I see fraud risk assessments on a residential conveyancing file. So that needs to be reviewed, and then checking the identity of the other side's conveyancer, which also falls under the property and mortgage fraud policy. And again, remember, keep the evidence. So that's probably one of the the non-compliances that I give on majority of practices I visit. And also property and mortgage fraud policy. It's not a mortgage fraud policy. So do make sure that if you're using something that's outdated, and it was an old Law Society mortgage fraud practice note from years ago, that it is actually updated, because I do see the same document over and over and over again, which is just called a mortgage fraud policy. Doesn't deal with property fraud. All those dream bar red flags do not appear in that. So again, just make sure that you've got what you need to have in place. Conflicts policy, read lots of conflicts policies, but quite often don't read whether you do act on both sides of the matter when you're acting for a buyer and a seller. And if you don't, then set it out. If you do, then identify in what circumstances and what controls and measures you put in place to make sure that you are trying to manage a significant risk of a conflict. So make sure that you look at all the requirements of 5.7, which is a conflicts policy. SDLT procedures, lack of the any reference to LTT, you know, top of mind awareness. You deal with properties in Wales, you know, they 99% of the time those quotes will always start off with an SDLT quote. Hopefully at some point further down the line it will be picked up with its LTT, because obviously there's differences in terms of the calculations. Come across practices recently whereby they have been caught out applying first time buyer relief when it didn't exist, although I believe it does now. So give consideration to that. The second pair of eyes, the verification of the calculation of stamp duty, is intended to be a second pair of eyes on that calculation. That's not happening in a lot of practices, or I'm seeing things whereby, you know, if only personnel who are less than 3 years qualified need to do that. It's a requirement, it's a must in CQS, so therefore it applies to all practices and all matters. And cross-checking the consideration between the transfer of the contract, the SDLT return against the payment out of client ledger. So this is intended to be a post-completion, post-payment process whereby you are checking that the right amount of stamp duty has been paid, so that you can pick up any anomalies and correct the position and identify why that anomaly or that error has happened quickly. In relation to leasehold procedures, make sure that you are actually fully explaining the difference between freehold and leasehold to the clients, and give full, clear advice. Twice in the last week have I read that scenario whereby, you know, here's your lease, please read page 12 and make sure you comply with the covenants. You know, to a layperson, that doesn't mean anything. So make sure that you do give that full advice, which the SRA issued guidance about last year, to say that it's not good practice to do anything other than clearly setting out to the clients in an easy, understandable terms as to what their obligations are. Reporting to the lenders, not seeing, you know, much evidence of this new requirement for checking part 2 and recording on the file. Not seeing that in practice at all, and also detailing the reporting requirements. So quite often, you know, there's no documentation there to set out that when we need to report to lenders, this is how we need to do it, this is what we need to tell them, you know, and that's all contained within the core practice management standard. So make sure it's documented and everybody knows about it. HMLR property alert service. I don't see a lot of documentation that sets out when we, you know, close the file and send our closed letter to the client, we will tell them about property alert service. And then obviously when I look at closed files and see that closing letter to the client, again, quite often it is silent on the point of HMLR property alert service, which is when we need to be telling them. And then finally, obviously it's a new requirement. Very few practices yet have got themselves into a situation whereby they have a procedure for, you know, checking the AP1 and cross-referencing and making sure that they are doing what they can do to avoid simple HMLR requisitions. So that doesn't tend to be happening in practice, and it doesn't tend to be documented. So those are the key areas of non-compliance, which I'm seeing in, you know, the majority of practices as a pattern and trend. So those might be areas that you want to specifically have a look at. And then finally, what's next? So in relation to CQS, not expecting any updates to the actual standard itself in the coming months. But what we will see is a change to the application process. So at the moment, this has been an online process, a paper-based application since 2010, and you'll be used to kind of submitting your application, and then maybe the Law Society come back with some queries after some time, and you might go back and forth. That's all changing, and it's quite a significant change. So there will be the launch of an online portal. Law Society will be making some announcements in relation to that very, very soon. It is imminent. So there'll be an online portal, and you will be notified, as you usually are, 3 months before your application expires or your accreditation expires. So you'll have that notification. There will be a countdown. So I think you're then notified at 2 months, 1 month, 2 weeks, 1 week of your expiry of your current accreditation, and your application needs to be fully completed and submitted on this new online portal by the expiry date. If it isn't, your accreditation will automatically lapse. So, and that's obviously going to put, you know, practices into a very difficult situation with, you know, particularly the lenders. So there is the ability to be able to apply for a one-off 1 month extension, and that is chargeable. The Law Society will be charging an administration fee for that. I think it's about £115 or something around that kind of mark. But you know, you need to start preparing in advance for this new online portal, rather than potentially the scrabbling about a few weeks before the application is due, on the basis that you might fire everything, you know, put a few outstanding items over to the Law Society currently with those to follow. You're not going to be able to do that anymore. The information and all the documents will need to be submitted on the online portal. You can, it's one of those systems whereby, you know, you need to make sure that you tick every box, answer every question, upload every document before you will get a tick in that section. Only when you get a tick in that section will you be able to complete that section, then move on and complete all the sections. You can come in and out of it, you can save and go back and all that kind of thing, but you will need to tick all of the sections, all of the boxes before you can actually make that online submission. So it's really important that you start early and you get together all that information before you find yourself in a situation whereby your accreditation might lapse. From this portal, the Law Society will be able to gather a lot more intelligence. So they will then be able to use that data to be able to profile practices, and that then will lead to them being able to identify a particular practice's areas of weakness, or particular areas where they feel that the practice is, you know, overexposed to a certain risk, and it might be that then is the catalyst for your practice being selected for on-site assessment at that point. So that's the biggest change for CQS in the coming months, and something that you do need to be mindful of. So make sure your SRO is keeping an eye out for those emails from the Law Society, which will give you the up-to-date information. I am going to hand over to Lisa now from InfoTrack. I do apologise that I have spoken far more than I should have done, which is typical of myself, but I just want to make sure that you've got all the right information so that you are armed going forward. But thank you for listening. If there's any questions, they will be at the end. But in the meantime, I'll pass you over to Lisa Edwards at InfoTrack.
Thanks, Tracy.
Thank you.
Could you stop sharing your screen, please?
Okay.
Thank you. Thanks, Tracy, again, and hello, everyone. I'm Lisa Edwards from InfoTrack. I think I do know a few of you have joined us today, so thank you all for joining. What I'm going to do just to close this session down is just talk about how InfoTrack organically supports you as InfoTrack users when meeting the criteria for CQS. Organically, by using our system, it helps you a lot in definitely documenting your evidence. As Tracy mentioned, say as you do, do as you say, provide evidence is key in the process of CQS audits. But it's just highlighting really by default how by using InfoTrack, you've got access to a lot of systems that meet a lot of the criteria in the CPMS. And of course, because you are integrated or about to be integrated with InfoTrack into P4W and or ALB, if you're not already, integration itself just gives you lots of key benefits in hitting key criteria. So what I've done, and you will have copies of these slides later on, is I've just taken a look at the slides, the areas of the CPMS changes, which Tracy has highlighted in sections. And if you go to the core practice management standards as well, you will see that it's logically broken up into sections, and it will talk about what they're looking for to meet the criteria. So what I've done from an InfoTrack point of view is shown how InfoTrack supports you in the journey of CQS assessments. So if we look at section 1, and I'll just briefly talk about these, but in section 1, if we look at a structure and strategy, for example, what is really valid when working with InfoTrack is that in majority of cases, all of your users are using InfoTrack. So one system across the firm just gives consistency. It means that everybody's trained on the same software, everybody knows how to use it, everybody knows how to retrieve documentation from that firm-wide account. So being a firm-wide account, InfoTrack helps in a lot of ways, and I do mention it quite a lot in the sections as we go through this. It gives you that standardization, which just makes things easier for you to train staff, get them to know your CQS policies and processes, and more importantly, how to store the evidence as well. So InfoTrack organically helps that way as well. Financial management, there's a number of areas and services that we offer at InfoTrack. And again, I know the majority of the people who are on this webinar already use InfoTrack, but you might not be using all of our products and services. So of course, if you're not, get in touch with me later on and I'll get in touch with your account manager. If you're new to InfoTrack and have never used InfoTrack, of course, speak to me afterwards and I can arrange a demonstration for you. But financial management is often the area that's pretty much untouched with a lot of law firms. They haven't actually taken the leap to do electronic client onboarding at the moment. It's quite a buzz topic at the minute about onboarding your client digitally. We offer that with InfoTrack and we've been using it now or offering it now for over 4 years. So we are experts in onboarding your client electronically. And of course, when you are integrated, when you have integrated InfoTrack with your partner for Windows and your ALB platform, all of the documentation on everything we do within InfoTrack documents straight into case. So you know where the documents are stored, your evidence is stored together. And that goes with electronic client onboarding as well. And of course, with financial management as well, managing the finances of each transaction is automatically done within your case management system. So all InfoTrack costings and so on appear on one invoice for you, but go directly to Ledger as well. So it allows the easy tracking of client funds and so on. And as I mentioned earlier, automatically being integrated into your case management system goes a long way to document evidence. Section 3, information management, and where we can help you by using InfoTrack is on GDPR, privacy and security policies. We have all of that embedded into our platform as standard, and particularly when it comes to electronic client onboarding as well, you are protected with compliance and GDPR. And again, one account for the full firm. And LMS integration. Our LMS integration is pretty good when you have to manage the information on reporting to lenders and so on. We have full integration with LMS, therefore your updates to the LMS portal are done automatically, particularly on your priority searches and on your AP1 registrations as well. And InfoTrack takes care of all of that for you automatically, as well as landing any documentation and correspondence straight into case. Section 4, people management, which is a new section that Tracy touched on earlier on. Again, when you onboard with InfoTrack, we give you continuous support, you and your users. So if you're not using all of our services, we can happily bring your users onto that. But when you get new users as well, we can actually train new users on how to use InfoTrack. And we often bespoke the training as well to fit in with your policies. So if you want us to interject in our training sessions, how your CQS policies are stored, how they work, we can easily bespoke training for you to get that message across as well, that this is one aspect of your firm's choice to use InfoTrack, and you want everybody to optimize that standardization as well. And often our firms build InfoTrack training into induction programs for new starters as well, which we're more than happy to take care of. You've got full account management support with us. Section 5, which Tracy mentioned, is the meaty one. When you look at the Code Practice Management Standards, it goes on for a long time, and there's lots of criteria to meet within there. And no surprises really, InfoTrack offer a lot of support in helping you meet that criteria. Recording key dates in conveyancing is vital, particularly for your priority searches and for your AP1 tracking and so on. By default, InfoTrack does all of that for you and keeps that log from forthcoming forthcoming tasks that need to be performed, but it's also historical as well. So the day that you start using InfoTrack and you start using the services that influence key dates, you will have a full automatic log of how you record that. And I'll touch on how that looks in a second. AP1 requisition management as well. As Tracy mentioned, a few common areas of non-compliance comes down to AP1 requisition management, missing requisitions, AP1s become cancelled and sometimes stay cancelled because it's quite hard to keep on top of them. The AP1 requisition management is seamless within InfoTrack. We do fully digital AP1 submission, but the system allows you to track what's happening with that AP1 plus any requisitions that come through directly. So all of these attributes, what are listed here, really do help you to meet the compliance. And again, by your users using using InfoTrack firm-wide, everybody's using the same system. Everybody should know what the policies are. Everybody can see where the documents are stored, and there's your evidence basically. But a couple of things that Tracy touched on, which are new to the CPMS, is the communication of leasehold information on leasehold properties. As some of you will be aware, we do offer property report as standard. As you do know, with InfoTrack, everything is devolved around pre-population. What comes from your case management system, from P4W or from ALB, pulls straight through to InfoTrack to pre-populate the data, and any data or services that you use through InfoTrack will further enhance your form filling. Basically, we pre-populate majority of the forms that you have to fill in, and one of those things that we logically and organically produce for you as part of using InfoTrack is the property report. So once all your searches are done, you've started to compile your SDLT and so on, you can create a report on title for your property, and we've built this to be one single screen, and it covers leasehold properties as well as new build and standard properties as well. So by default, you will have all the leasehold information stored on that property in your property report. So there's no risk of not communicating the correct information for leasehold property. And because we integrate with HMLR as well, we will read the lease as you order it from our platform, and that digital information is then pre-populated into property report. So you can actually produce a leasehold report really in less than half an hour by using InfoTrack, but you will never ever not report on the key data which meets the requirements of CQS. Lender handbook as well. A lot of our customers never realise really that we have the full lender handbook on our system, and it's free for you to use. And I'll show you where that's stored in a second. So again, lender handbook requirements are forced within CPMS, and you need to provide evidence on every single case that the lender handbook has been addressed. With our system, we make it easy. You can set up alerts when things change at the beginning or the end of the transaction, and you can set alerts when the changes are made to that particular bank, and we notify you straight away with a report which highlights the key changes, allowing you to read, to get clued up on what the changes are. But more importantly, the document is stored on InfoTrack and of course within your case management system, so you have the evidence to prove that you are checking the lender handbook as standard. SDLT as well, of course, we do stamp duty, so you can compile and submit your stamp through us, and of course we have a calculator on there as well. So as Tracy mentioned, providing evidence that you use a secondary calculator to get the calculation right for the stamp duty payment is key to CQS. You can evidence that with InfoTrack. And also Section 6 client care. In the CPMS, Section 6 looks at basically ECOS, LMS and property report, which allows you to back that particular section up. And then file and case management, of course, we know that there is a Section 7 in core practice management standards, and being integrated into, or having InfoTrack integrated into your case management system helps massively because of the data storage. Now, what I'm going to do is just quickly flip over to InfoTrack, just to show you where these things live if you're not too sure. Hopefully you can see the website on my screen. Faye, I know you're looking for me. Can you see the InfoTrack website? For anyone?
Thank you. Sorry, yes, I was just trying to Yes, that's showing clearly. Thanks.
Oh, thank you very much. Sorry, technology sometimes lets you down, and sometimes flipping between screens when on a webinar, sometimes you can't see what I'm seeing. So I'm glad for that. Thanks very much, Faye. So this is InfoTrack. So everybody on the website, on the webinar, may be familiar with this. You see a slightly different version of this screen when you are accessing InfoTrack through P4W or through ALB. Of course, when you enter InfoTrack through case management directly from the case, you see a truncated view of existing orders. You will only be looking at the order that is relevant to your case management file. So ignore the existing orders for a second, but I just want to talk around the areas that are highlighted area which can help you with CQS requirements. So over to the left-hand side, you will always have a menu showing you your dashboards, and over to the right-hand side, the news and events and the calendar is stored. Now, when you look at this through case management, it is at high level. It's not just for that particular case. So the two navigation bars to the left and to the right are relevant for the whole InfoTrack system. It's only what's in the middle that's relevant to the case. So you can access the calendar whenever you wish. Now, I mentioned that we organically store key dates. This is where the key dates are stored. So if you have an OS priority expiration, you can see that it will show you for yourself and for everybody else in the firm if a priority search is due to expire. So you never have to set up your own spreadsheet or a log as to how those expired. Everybody's notified and everybody can see here when an expiration is about to happen. And if Scott Bazzinis, he was on holiday at the moment, but because I'm at a firm and part of the firm, obviously, and he's my colleague, if I know he's away, I can actually deal with that on his behalf. So it's a firm-wide account. And as I mentioned, when you start using InfoTrack and you start using this for priority searches and AP1s, this calendar automatically becomes historical. So you will see here, you can see what's going to be happening for the week, but it will also give you for the full amount of time that you've been using InfoTrack as well. So it's a full storage of all key date management. So it's a nice thing to show when you are being audited. At the top of the screen on our workflow at the top, I'll just highlight some of the products and where they live. So if you haven't taken advantage of them currently, you know where you can have a peek and a sneak peek, and we can help you with that later. So client onboarding, you will see here that the journey of onboarding a client right the way through to completion is highlighted through this workflow. So there we have anti-money laundering searches, which you can order standalone, or you can actually AML your client through onboarding as well. So if you want to get your passport, your driving license evidence, you want to send out your contract, you want to do TA forms, and a sale, for example, or a purchase, and you want your client to actually fill in the protocol forms and so on, this is where electronic client onboarding becomes a reality. So you can verify their ID through us, you can carry out the AML check through us, and you can also check verification of funds as well. So source of funds. If your client is an online banker, they can actually give you access to a year's worth of bank statements on their bank account. Up to 3 accounts on their bank account can be verified as well. And that's done automatically and stored straight into case and all digitally enhanced as well. So that's electronic client onboarding. And again, the evidence of onboarding your client lives in case. So it's very easy to locate and show. So of course we do searches and quoting and so on. Land registry, you're all familiar with. But remember what I mentioned about LMS integration as well. If you use us for priority searches, you will see here that you can link any of the priority searches through to your LMS portal straight away by default, and you just basically select the case number where you want that to go. So if you're not using that or you weren't aware of that, do let us know and we'll get you activated there. Now, productivity and bank check is the area where people tend to forget on InfoTrack. We have electronic signatures through Sign It, but that's where the property report lives. So I mentioned earlier that naturally, if you use us for searches and so on, your property report will build straight away for your report on title. So you will see here that we deal with leasehold and unregistered, new build and so on. So if you've bought the lease through us through the land registry section, you will be able to produce your leasehold report through us, and it will read any information that's relevant to that particular property from the digital document that comes back. So that will pre-populate that for you in the report itself. When you run the report, everything will be as it should be for that particular property. And of course you can check it, see it, add to it if you needed to, but the key information will automatically come through to meet the requirements from CQS. So if you haven't looked at property report yet and you haven't seen how it operates, do take some time out to talk to us about it, because it does save you a hell of a lot of time. And again, once the property report is built, it's there in case, ready for you to send to your client in parts, incrementally or in full. And it's stored automatically within your case management system as well. So that's property reports. Going back there as well, bank check. So this is where you can actually check for fraud and so on. So we've got lawyer bank check there, which links you to our Confirm Me product, which allows you to check the other side's lawyer, client bank check as well. And then here's the lender handbook. So again, a lot of people don't realize that it's the full lender handbook on here, where you can actually search all parts of the lender handbook, part 1, 2, or 3. You can search for updates as well for any particular bank, and then you can manage alerts. So if you want to set up alerts for any particular bank, you can actually change this whenever you want to. It's default to your own login. So if you just basically wanted to keep abreast of all banks, which you probably won't want to, but if you wanted to, you can, or you can specify the bank. So if I'm particularly interested in Bank of Scotland or Barclays Bank, for example, I can click that, update my alert preferences, and I will be alerted via email and via InfoTrack as well when anything changes on that particular bank. You will then be given the documentation in full as to what those changes are, and they will automatically drop into your ALB case matter or your P4W case matter as well. So if you're not using the lender handbook yet, again, take a look. It's quite logical and intuitive to use, and if not, get in touch with your account manager and we can help you there as well. I know I'm a little bit short of time and I've overrun a little bit, but just finishing off on some of those areas where we lend ourselves to supporting you with the requirements of compliance. I'm going to finish off with AP1. Of course, that's where SDLT lives as well, in the post-completion section. But I'm just going to concentrate on AP1 to show you how quick it is to build your AP1 submission through InfoTrack. You never leave the screen to do that. It's 98% pre-populated as well when doing it from P4W or from ALB. It takes literally less than 2 minutes to compile an AP1, and you can submit it directly to the land registry here as well. Now, the beauty about this is that once you submit your AP1 through InfoTrack, back to those dashboards over to the left-hand side, it will allow you to monitor the progress of your AP1. So I've just clicked on the AP1 dashboard over to the left, and you can see here I can look at the status of any AP1 that's been raised within the firm, and I can see if there's a requisition outstanding, completed, and so on. And you will see that the AP1 dashboard has a little token next to it, which just basically highlights that there's something for me to address here. So users of InfoTrack, take a look at that and think, oh, something needs my attention. Click on the AP1 dashboard. You can actually respond to requisitions directly from your InfoTrack screen. And anybody can do this in the firm. And this is your audit trail as well of how you've managed the requisition. It will give you a full documented audit trail here, and your reply to the requisition goes directly to the land registry operator. It doesn't just go into a box somewhere for land registry to pick up. This is going directly to the land registry operator who raised the requisition. And of course, you can view all documentation from here as well. So if I wanted to see the requisition, I could. And you can actually obviously respond to the requisition or request an action as well. So if you just basically wanted to request an extension of time, you can from here. But if you're ready to respond in full, click on respond to requisition, and you can see that this goes in here. Now that's stored in InfoTrack as default for your audit trail, but every single thing is case specific when you've integrated InfoTrack with your case management system. So in P4W or your ALB case, all of the responses to the requisition will be stored directly on that file. So going back to what Tracy mentioned earlier about do as you say as you do, and document your evidence. The evidence documentation that you get from InfoTrack is standard. Every single service that you use with us, where a result is produced, will land in case, and that covers everything from onboarding your client right the way through to lender handbook updates, right the way through to AP1. You know where your documentation is going to be stored to actually produce that as evidence. It's all within case. And that's one of the advantages of working with us. So just to close off then, just before we go for Q&A, I just want to go back to the slides. Now, we do work very closely with CQS assessors, of course, Tracy, and of course, directly with the Law Society as well. And one thing that the Law Society have put into the CPMS standards for 2022 is a guidance note in there, and they are acknowledging that digital storage of documentation is the easiest way to actually collate, curate and supervise and share. So this is a statement directly from the Law Society, which is within the guidance notes of the CPMS. And it speaks for itself, really. There's no actual requirement to store things digitally, but it is easy to curate, supervise and share when held. So thank you very much for your time. For those people who are not using InfoTrack yet or want more evidence of how it works, do get in touch with myself for anything really. And thank you very much for your time. So I'm going to hand back over to Faye now, just to close down the session. Thank you very much, everyone.
That's great. Thanks ever so much for your presentations, both of you, Tracy and Lisa. That's much appreciated. Now, we haven't actually had any questions in, and as we have overrun, we probably should wrap this up. But there are some details on your screen right now. So if you do have any other questions or you'd like to get further information, take those contact details down. Lisa will be more than happy to come back and answer any questions that you may have. I hope you found this session helpful and informative. So if you do have any other questions about anything that you've learned today, either about CQS or about the technology available to support your compliance journey, then please do contact us using the details on your screen, or else reach out to your account manager separately, who'll be happy to assist you. As mentioned at the beginning, this session is going to be recorded, so we will send a copy to you all along with the notes so that you can refer back to it. So all that's left to say is thank you very much for joining us today, and have a lovely rest of your day. Thank you very much indeed. Take care. Bye-bye.